Retail theft, it's decreasing in San Francisco, as is the illegal resale of stolen goods on city streets. So good news there.
That's right. But those same offenders may find it easier to walk free because of a recent California Supreme Court decision.
ABC 7 Eyewitness News reporter Leanne Melendez here for an in-depth look at a new hurdle in fighting crime.
Right.
One step forward, two steps back here.
Well, things are changing, or are they? So we are moving the ball forward when addressing retail theft. Those words coming from San Francisco District Attorney Brooke Jenkins. She, like others, say there is still a lot of work to be done, but there's a new obstacle which has gone somewhat unnoticed until now.
Ma'am, stop right there.
In a single night, 22 people were arrested in San Francisco for shoplifting. The video was provided by the SFPD organized Retail Crime Task Force.
Hey, stop running!
Today, the consequences are more severe. Since December 2024, a district attorney can ask that a shoplifting or petty theft charge be filed as a felony if that defendant has 2 or more prior convictions for theft-related offenses.
We have filed well over 100 of the 666.1 cases, which is really telling us that there are people who are running around with prior convictions who are continuing to steal, and we've been able to one by one, apply more serious charges to them, which matters.
The use of police drones has also been instrumental even in pickpocketing cases.
After confirming 3 separate pickpocket thefts, officers coordinated an arrest operation.
Here's what they told us back in March when we visited the Real-Time Investigation Center.
We're absolutely using that as a message to send out that if you come here to San Francisco, you're going to get held responsible for what you're doing.
But despite these tougher laws, some suspects are released by the courts, even though they have committed several offenses. Take the case of a man named Tyrese Boswell, arrested last December for 18 thefts at a Walgreens. He was then released by a judge, and according to his complaint, Boswell was involved in 7 additional thefts at another Walgreens. He was arrested in April and again released, pending his court date. Court documents state that he then returned to the same Walgreens 2 more times and arrested a 3rd time. He now remains in jail. According to police, his theft spree totaled nearly $40,000. In case you're wondering, some of those stolen items are then illegally sold on these streets. But all police can do is cite the person unless there's a warrant. Here's what we saw. Police confiscated a bag full of items from a man whom, admittedly, had sold stolen goods many times in the Mission District. How about any stolen stuff?
Well, I mean...
From another party?
Yeah. Stuff,
yes?
Yeah, stuff like that, yeah. But,
So did they...
They took the most expensive stuff I had, Levi's, and they wrote me an infraction. They ran my name. They just hassle us. If we have a warrant, they'll take us to jail. They just don't give us room to operate.
Jenkins and other district attorneys in the state are now concerned that the courts will not be able to keep some suspects in custody for committing nonviolent offenses like shoplifting. That's because in April of this year, the California Supreme Court ruled that jailing a person before their trial simply because they cannot post bail is unconstitutional.
We cannot, as a system, hold them in court without being allowed to post bail that they can afford to pay.
An example of what could happen recently did when a man accused of torturing a kitten in San Francisco was released and was a no-show for his arraignment. A few days later, Reno police raided a home to arrest him for allegedly adopting more kittens and abusing them.
Anyone who's committed nonviolent crime, and I mean nonviolent against another person, not an animal, anything like that, is going to be back out into the street most likely.
So we're not advocating one way or another with regard to the state Supreme Court's decision, of course. This decision stems from a case where a man found a credit card, used it to try to buy a $7 hamburger, was arrested. Bail was then set at $75,000. He couldn't pay it, and then he spent 6 months in jail waiting for his trial. Still, a lot of district attorneys in the state very concerned about the consequences of this ruling.
Yeah, well, that seems to be the extreme. That case,
Yeah.
a $7 hamburger. But
Rare,
How
by the
do
way.
these people keep getting released from jail? Like, is it an overcrowding situation? What?
Well, I mean, you know, for the longest time, California has said, well, you know, if it's a minor offense, then they shouldn't be in jail. And that's why we came up with this 666.1, which is if you commit more than one, several, and then you commit another crime, which was before a misdemeanor. Now it will become a felony.
You got the one guy at Walgreens 10
it's
times.
little by little, I know, and they keep on coming.
Yeah, thank you, Leanne.